let me introduce the panel again from beginning with your left, audience left to right. We have Raghav Bajaj, who is a partner at Haynes and Boone. And then next to him, we have Heath Briggs, who is a partner at Greenberg Traurig. Then we have next to Heath is Meredith Addy, who is the managing partner and co-founder of Addy Hart. And last but certainly not least is Lori Gordon, who is a partner at Perkins Coie. So I thank you all for joining us here today to have this conversation. And what I would like to do, and we can go in the order in which I introduced you, to get your preliminary thoughts. So Raghav, let's start with you. When you hear the topic, navigating these disparate challenges and different forums, what's the thing that comes to mind first and you'd like people to immediately start to think about from your perspective?
The need for coordination. If you're part of a litigation team, you've got a litigation team and you've got a PTAB team. Sometimes they're the same people, sometimes there's different people, but coming up with a coherent strategy and coming up with a coherent plan for claim construction, for infringement read, for invalidity is really critical, because any inconsistencies can really destroy you in front of one forum or another, and lose your credibility. So I think that because so many of these proceedings have parallel litigation, you need to be speaking with one voice and not bouncing around between theories.
Great. Thank you very much. Heath, let's go to you. What's your preliminary thoughts on the topic here today?
The first thing I need to know is what court I'm dealing with. Am I in Texas? I'm in Delaware. Where am I? How fast are we going? Do we have fintive issues, which I can get rid of with Soteric? Do I not? And coordination, like he said, we have generally PTAB teams, mixed litigation with prosecution. We found it works best along with a dedicated litigation team for litigation counsel, and coordination, as he said, is just absolutely critical.
Yeah, no doubt. It's coordination and having one voice is very important in this area. All right, thank you. And Meredith, your entree to this topic.
Well, alongside with Heath, I am looking at where are we when we file the district court action, and does that really matter? So putting aside some of the very fast district courts, what I'm going to end up wanting to know and try to figure out as soon as possible is, what is my case likely to look like when I get back from the federal circuit after the PTAB? Because that's when I really get, as a patent owner, that's when I get to go on the offensive. So I kind of got to be able to, as best I can, find a projected path, because I know that's where this is going. Mm-hmm. And if I can't find a projected path through the weeds, through the district court, the stay, the IPR, probably the appeal, it's not worth it getting into this fight to begin with.
Okay, great. And Lori, last but not least, your preliminary thoughts on today's topic.
Yeah, it's tough to be last on this panel on preliminary topics, but of course, I echo what everyone else has said. I primarily represent petitioners, so the first thing you really need to do, particularly with this, if you find yourself in a Texas court, is to really try and get kind of a 360-degree view of the field, so the path forward and the strategy. And sometimes an IPR may be not the best strategy. You may want to try a re-exam. You may want to go to that path. So I think, to me, when you're dealing with concurrent or parallel cases, which you almost always are, you need to understand where you are very quickly and pick the best strategy for the bigger picture case, rather than just kind of throw yourself into invalidity searching on day one.
Okay, great. Thank you very much. So now, I had asked Meredith if she would lead the conversation. I will also participate, but I don't want to take too much time away from the esteemed panel with my thoughts from the peanut gallery. Since you guys are the front line folks doing this and trying not to open your mouth to insert your foot in one tribunal while taking it out of your mouth at the other tribunal, I thought it would be best for you to all have just a conversation amongst yourselves. I'm happy to participate. I don't have a lot to offer. I have more questions than answers. So, Meredith, you want to take it away?
All right. So I think there's an issue that got resolved at the Federal Circuit last year. The case is Ironburg. It's PTAB estoppel. I think we've all been waiting for that sort of guidance for a while. And so I'll start with Heath. What has happened since Ironburg? Maybe we need to go over it lightly.
Yeah.
And have there been any great district court developments that help us understand how the district court's going to deal with this issue?
Yeah, I'm going to read from some notes here, so just give me a second. So Ironburg came out last year, 2023, and it's basically about the skilled searcher standard and what a skilled searcher would have reasonably found in terms of prior art as it relates to the PTAB proceedings. And the reason this came up is patent owners arguing, look, they should have found this prior art, they didn't. Petitioners saying, no, we didn't find the prior art, we just now located it, and so we could not have reasonably raised this prior art in the district court proceedings. The Fed Circuit has now said, well, you have to use a skilled searcher standard, and let me just tell you what that says. It says, stops a petitioner as to invalidity grounds. A skilled searcher conducting a diligent search reasonably could have been expected to discover, as these are grounds that the petitioner reasonably could have raised in his petition. So it's very clear the skilled searcher standard applies now. Well, what have district courts been doing? Just recently, just last month in SDNY, they said this: a skilled searcher conducting a diligent search district courts have concluded that a skilled searcher would have been able to find a particular reference when the moving party, 1, identifies the search string and search source that would identify the allegedly unavailable prior art, and 2, presents evidence, like expert testimony, why such a criterion would be part of a skilled searcher's diligent search. Well, why is this important if you're a petitioner or patent owner? Well, if you're a petitioner, in my view, you got to make sure that you're working with the right outside search firms. We typically do. You got to make sure you're documenting those, and then you've got to make sure, in my opinion, that your outside search firms understand that this is the criteria they're up against, so that when you get to district court and additional prior may or may not come out, you at least can say in that proceeding that you've tried to fulfill that standard, and therefore you are not stopped for bringing the additional prior art that is now located.
Raghav, my understanding is this is like an affirmative defense, in that the Federal Circuit said that it's actually not the former petitioner or current defendant's burden to prove that they had a skilled searcher who was reasonably diligent. I believe they said it was up to the patent holder to prove that a skilled searcher was reasonably diligent. How does that affect how you go about navigating between these two forums?
Right, that's exactly right. So it's on the patent owner, the person advocating for the affirmative defense, to establish that a skilled searcher reasonably could have found those references. And so looking at the district court cases that have addressed this so far, it's really important to kind of find the extremes and figure out what the right balance of what a skilled searcher could do. Some of the district court cases have been very straightforward. It's not a scorched earth search. If the searcher took 100 hours and found it, that's not going to be a reasonably diligent search. That's something that's going to be a reference that could be raised even with the estoppel. It's also good to consider hindsight, right? If you have the reference and you can tailor the search string to uncover that reference, district courts have looked at that fact pattern and said, we're not going to consider that evidence because it's too narrowly tailored to find that specific reference. So you really have to, as the patent owner, just as the petitioner has to find a good prior art search firm, as the patent owner, you've got to come up with a good story and find the right expert. This is a new industry for experts to kind of recreate this search and find what the petitioner is advocating for in district court. Otherwise, they're stopped.
I agree. It's interesting because originally the burden is on the petitioner / defendant and the PTAB, and now, or once you get back to the district court, it's almost like, well, the burden does shift, but the patentee is going to have to come up with someone who is a skilled searcher. Who is a skilled searcher? Lori, do we know who a skilled searcher is? Is there any jurisprudence on that yet?
There's no jurisprudence that I know on what makes someone a skilled versus an unskilled searcher. There are numerous search firms out there that we all use that I think would probably fit the bill of a skilled searcher. I will say, from the perspective of my cases, I never, you always assume that you're not going to be in a position where you're going to win this fight on kind of could have or reasonably could have raised. So, when you start the process, we always make sure to do a very diligent search early on for product prior art and make sure that our prior art that we found for the paper prior art doesn't disqualify our product prior art. So, I think there's still a lot of tire kicking to be done on the estoppel, what raised or reasonably could have raised means. And we had some recent decisions from the board on Sotera stipulations that kind of throw some question marks into that even more. So, I think from maybe stepping back from a big picture, when you're in this parallel litigation perspective, I'm pretty pessimistic. So I always assume you're not going to win that fight in the district court. So if you need to have an invalidity case for the district court, if you lose at the PTAB, focus in on product prior art very early.
I had a follow-up. I believe you mentioned that you want to make sure your paper prior art doesn't invalidate your product prior art or make it not as useful. Can you explain what you mean by that?
Yeah, so there are some district court decisions that have said that if you're using, so say you're using the manual for a product in the PTAB or a patent describing the product in the PTAB, then you can't go into the district court and use that product as prior art if you're stopped. So you certainly want to avoid using a reference that is close to or describing your best product prior art if you need to preserve something for the litigation.
So, Meredith, I want to ask you about that same area. And I know you, not that you only do federal circuit, you do all of this stuff, which makes you the perfect moderator because you do see it at PTAB, federal circuit, district court. But specifically at the federal circuit, what do you think the federal circuit is going to do with Ironburg?
Nothing now, because it's done.
Right. No.
The Ironburg progeny.
The issue. Wise ass. See, that's the problem you get when you put your good friends on panels. They occasionally will just slap you. Not that these two, Scott or Jim, know anything about that. But
Well, it's interesting because if you think about, there's the skilled searcher and reasonable diligence. They can have a lot of fun trying to define that. But I do think that if the lower court has addressed these issues, as I think my colleagues were saying, there's going to be an expert probably declaration in here. If the lower court has addressed the issues properly, then the federal circuit's going to give deference to what the lower court did when this comes up, would be my expectation.
So, and I'd like to get all of you to weigh in on this if you can. And there's no answer to it. So I'm asking you to pull out your crystal ball. And Meredith, maybe I'll start with you. What do you think AI is going to do to this? And it's a real, for me, much more interesting question when you think about the federal circuit, because if you look at their transfer law, we still live in 1700s with horse and buggy, and it matters where your server is actually plugged into the wall and that sort of thing. So, I mean, what are they going to do with AI and AI searching?
Obviously, this is a progressive issue, and it's an issue that's going to change as the court becomes more familiar with AI and what AI can do. And I would imagine the first cases that come up to it are going to have something on the equivalent of a skilled searcher that's giving a declaration about how he was the hand holder for the AI. And the AI can't just run off and do it itself. I mean, it could, but I think in the beginning, the federal circuit is going to feel a lot more comfortable seeing some caretaker for the AI that could say, this is how I instructed the AI to perform the search.
And I wonder, as I was thinking about this, I wonder whether almost the other side, the patent owner, for example, could come and say, hey, we actually did an AI search. This is what we found. They could have found it if they wanted to. This was not impossible. This was not like kicking the tires on some lost village in Africa where, years and years and years ago, there were litigators that were known. If there was prior art any in the world, they were going to find it. And they traveled to bizarre places to get it. It's not the world we live in. I mean, do you think that there will be a role for good AI searches done by patent owners to demonstrate what you could have come up with?
Go ahead.
Well, I could be facetious and say AI can't be an inventor, so how could AI be a skilled searcher? I could start there just for kicks, but right. But
see, but but it's funny you say that, right? Because that's true. But do you really think that the courts are going to look at it that way?
no, I don't. I'm just joking.
So I was thinking AI might actually invent the prior art and then tell you where it found it.
Well,
So-
to be
they'll
fair,
invent it, but
ChatGPT
they won't
has
tell
done
you
that.
where.
Yeah.
So I was going to say, you joke about that, but AI is only as good as its training, and it is quite possible that AI could invent references that don't really exist, right? So,
Well, it
so-
does it with citations in these briefs that are filed.
Yeah, so I think we all have to be really kind of cautious of AI, and I think the battleground would be like, how is the AI that found this trained, and can you kind of corroborate the prior art that the AI found?
Well, it should certainly have to be a publicly available AI. I mean, if people are using private AI and nobody else has access to it, how are you supposed to prove that, I'm assuming a skilled person criteria is the same thing as a PCETA, just like some average searcher. There's not a real searcher. And so if you're using private databases, that shouldn't count. And personally, in my opinion, you have to be using public ones. If you're using public ones, what are the search criteria you put into public ones? And then we're just back to what the district court just said. And getting back to your question about where's the Fed Circuit going next with this, well, if the district courts start having different criteria for skilled searcher, they're going to need to clarify that. And that's going to be coming pretty soon because Ironburg came out last February, so only 12 months from it, and then the estoppel issues are just starting to come up from that because people are just starting to get back to trial because they were in IPRs at the time. And so we're really going to start seeing in the next 12 to 18 months really what's going to go on with skilled searcher and district courtless cases.
Yeah, Raghav, you wanted to?
Oh,
jump in?
the only thing I was going to add, some of my co-panelists have mentioned that, but with the system prior art, where this might go, Judge Bryson was sitting by designation in a case in Delaware and kind of compared the two approaches for system prior art, whether it's cumulative or the same as the document. And he came out on the side of if it's system prior art, it's allowed in even if it is somewhat duplicative of a patent reference. And that was the case was Prolitech v. Centair. And so Centair had presented in the IPR a patent, and then in the district court presented two products that were characterized in the patent. Judge Bryson found that to be okay, but I think there's, a split of district courts on that, and something the Federal Circuit might address.
So just post Ironburg, in a case where you might have prior art that you're happy with, are you counseling clients to go out and do a search now just in case so that you have something to point to if this dispute ever percolates later down the line?
I personally would never file an IPR without doing a search, even if I had the best piece of prior art. I never want to leave that to the unknown.
Yeah, I mean, I'll echo that. I mean, we now know what the criteria is. If a skilled searcher can find it, and it was found and agreed to be that, then you're done with that. So you better evaluate that prior art. I mean, you have to bring your best case, and you only have one chance usually. So you might as well be doing the search and making sure you satisfy all that criteria and bring in the best prior art.
So I'll throw a little bit of a monkey wrench in here because I personally am not a big fan of prior art searches. I mean, we do them in every case, but I'll say the best prior art is generally not found by your search firm. It's found by either the attorneys working in coordination with the experts or the attorneys themselves, right? So, we focus a lot on creative search strategies, and I think, I filed probably 20 or 30 IPRs in the last year, and I don't think in any of them I used prior art that a search firm found, right? So now, how does that map to your skilled searcher standard when it's the attorneys finding the prior art, and how do you document when you have a team searching or your expert searching? How do you document kind of that process. So these are things to think about if you are trying to be the most conservative to have something if you lose the IPR. But like I said, I always assume that path is going to be foreclosed. So you better win and have a different strategy early on.
So it's interesting. Will there develop maybe a skilled searcher could be a PTR, an IPR litigation team, that does this all the time. They could logically be a skilled searcher, and they could go through what they did, and that could be in a declaration.
Right.
Or is it just worth it to go ahead and spend the money because cost per risk, the money to do a search is low compared to the amount of money that you're going to spend per IPR petition. And I think we'll see both.
Right. I agree.
Okay. I don't have anything more now. You can carry on.
Well, I have a couple of issues. I don't know which one to pick. Probably the one that doesn't send me on a rant until later.
I like rants.
We could all find rants. So I think there's couple of really interesting issues. They're related in that they come up after the petition is filed. And the first one, of course, is claim construction. And so I think touched on in an earlier panel that you got to be sure your claim construction is solid. And obviously, I think that the thing that comes up most of all when you're dealing with these parallel litigations is sometimes you're going to get to claim construction before you get to an IPR being instituted. And how do you weigh those two different forums and make sure you get both a claim construction that is favorable to you, but also a claim construction that is going to be good for your position at the PTAB? And I'll start with Lori.
So you're going to make me rant first.
Go for it.
Well, my rant would lead us into definitive because I think that created this dynamic where you're rushing to file your IPR before the litigation has time to really unwind a little bit so you understand more about claim construction and positions and things like that. And so I think FinTIV has done a big disservice to having a quality invalidity case presented. I think it's best to let the parties have the time, and Congress gave us a year, and that's what we should have. So that's my mini rant. I'll step off my soapbox and talk about claim construction. So I think, the issue with claim construction, particularly in the dynamic we're in now, where your IPR is often leading your district court litigation, when I go into an IPR, I often argue multiple claim constructions in my petition, right? Because you have the claim construction that you think is going to be for your case, the best for your case. So you have to have an understanding of your non-infringement position, the prosecution history, the international kind of family prosecution history. So you get a whole view of that. So what you think the claim should mean. Then sometimes you'll have a slight understanding of how the other side is going to think the claims are going to mean, but you don't have an adjudication at this point. So I often file an IPR saying, here's why we win under what we're proposing for our claim construction. Here's why we win under what we think the patent owner is going to say these, and I'm talking from the petitioner, what the other side is going to think, and we know this from the infringement contentions or the complaint. And so now the board has both sides, and they can say, well, claim construction doesn't matter because, this party wins regardless of claim construction, so they can maybe put it on the table.
And what about the strategy of a petitioner of not filing a claim construction at all because you don't really know what it's going to be, so you take the position that the PTAB doesn't have to do a claim construction?
I think that's consistent with what Lori was saying, that you kind of try to attack all angles and anything that's kind of reasonable. There may be a patent owner construction, and again, I'm speaking on the petitioner side because you start out first, a patent owner construction that is extremely narrow, and if that is a possibility, either you try to find art that hits that, or you demonstrate why that's not reasonable and not the plain and ordinary meaning. Because if you are unrebutted and you don't get a reply brief, which isn't a given these days, you want to make sure that your petition has everything that you need in there to support your unpatentability case. I think one of the other aspects that parties still find difficult, and I find this difficult to this day, is the means plus function issue. Balancing that against a potential indefiniteness case in the district court, and figuring out, well, do I file an IPR at all, or do I just wait for an indefiniteness ruling and hope that saves the day? That can often depend, again, on which district court you're in. Some courts are very reticent to granting summary judgment of invalidity on indefiniteness. So there's just a number of considerations.
Heath, what would you do in that situation where you had a 112 issue? Because I think, for those of you who don't know, you're going to have to provide a construction at the PTAB, but at the district court you're saying, I don't know what the construction is because it doesn't satisfy 112.
Well, we did this in Pursuit, so I don't know if anybody knows the Pursuit case. We handled that one. So we argued indefinite and, oh, by the way, the claims are invalid even though they're indefinite. PTAB said we can't do that. Fed Circuit came back and said, well, you can in this circumstance, and here's the reason why. More recently, we tried to, without success, admittedly, we filed 2 different petitions. You can file 2 petitions if you put in the reasons, and why you're putting in the reasons. One of the reasons was these claims over here are not means plus function, easily construed. We know what to do. These claims over here, they're asserting all the claims, by the way. They're asserting 28 claims against us. So I got means plus function over here. I got regular claims over here. Even though the means plus function claims are indefinite, in petition number 2, Your Honors, PTAB, you can still do it under Pursuit. They were like, no, if you're not going to take a claim construction position on the means plus function, we're not looking at this, so they just punted on it. So I would not recommend that approach. But if they're in the same petition and under SAS, you can get it in that way. And then you maybe can backdoor your indefiniteness with getting it in on the first set of claims, claim construed, means plus function. We don't know what they mean, but they're still indefinite, and you have to figure that out because SAS tells you to do so.
Right. So I have maybe a slightly different approach, and it goes a little bit with the timing consideration. So if you have means plus function claims that your litigation team wants to preserve indefiniteness, then we often will wait on the IPR until you exchange some form of claim construction with the other side. So the other side, for example, again, speaking as a petitioner, you get the patent owner to say, these are not means plus function, or these are means plus function, and here's the function and the structure. So you have something to go then in the IPR and say, we reserve the right to argue these are indefinite, but this is what the patent owner said, and we're filing this IPR under the patent owner's construction. And there are PTAB cases where the board has allowed petitioners to move forward under patent owner's construction. Now the risk is that the PTAB agrees with the patent owner, and that somehow comes back at you in the district court. But it's a way to preserve indefiniteness for the district court and file an IPR. But then you have kind of you're waiting until that happens at the district court. So you're probably going to find yourself in a Sotera stipulation situation.
What about you?
I have been on the patentee side, the recipient of an IPR petition that dealt with it by saying we can't construe these 112s. I mean, we can't construe these means plus function, but we can't construe these other ones. And I was lucky enough that PTAB denied the institution all the way around. I was going to ask, would any of you in a means plus function situation not provide a claim construction? Just, we don't need to construe this because we can tell it's invalid without a construction.
Well, that's a violation of
rules,
the rules.
yeah.
I would
The
never
rules
do
say
that.
you get kicked out already.
So no.
For all those PTAB judges out there, I would never do that.
So that leads into kind of the next issue, which is means plus function aside. So now we're dealing with straight claim construction. The Federal Circuit has been clearer recently that if a petitioner chooses not to put in a claim construction or puts in a claim construction and the board uses either the patentee's claim construction or another claim construction, the petitioner should at least have the chance to respond. And I think that makes sense. And so what, on my side as a patent owner, we see a lot. It's the petitioner saying, we don't think this needs to be construed. And we come in and we say, well, it needs to be construed like this. And, then we have opened up another issue. Because as 35 USC, I think it's 312A says you got to get everything into the petition. But if we open up this new issue that petitioners didn't raise, now, we're in a land of they're going to get a reply on it for sure, and we're going to get a surreply to deal with it. And I guess I wondered if you guys use that strategy because I absolutely see it a lot.
Can I jump in here? Because and this will come up tomorrow in our ethics panel. We were just talking about there haven't been a lot of ethics cases at OED relating to the PTAB. The couple that have fallen in this area where this was not an ethics issue, but there was other stuff going on. But the petitioner filed something, did not offer a construction. And the PTAB then said, well, the burden is yours, and you didn't offer a construction, so therefore we side with the patent owner. And there may have been some ethics stuff going on there that made the court do that, but are you saying, just so I hear probably, that the petitioner does not offer a construction, then even though they're the ones with the burden, they force you to construe it, and then they're like, oh, and it's wrong for these reasons. Is that what's going on? Why don't the judges just throw it away?
So I want to maybe step in and defend petitioners a little bit here.
I'm 3-1 here.
Well, I don't think it's that where petitioners stand back and like, oh, we're going to hide behind the covers and like, when I'll speak for myself, when you prepare a petition, you think about like, this is the term is the plain and ordinary meaning of this clear to an expert, and if it is, then you don't need to construe it. Or if there's not going to be a dispute, you aren't required to construe claims where there's going to be the dispute's not going to turn on claim construction. Where you have a problem is where there's a claim term, and it's pretty clear that it could mean X or Y. And as a petitioner, I would never going into an IPR knowing that there's a strong potential there could be an X or Y situation and just hide behind kind of the covers, right? So you always go in and say, here's what I think it means, and if patent owner might say it means Y, and here's why my prior art wins the day regardless of how it turns out.
Okay, so to bring it back sort of to the theme of this is the comparing and contrasting and that navigating. I don't think I've ever seen. Has anybody ever seen in district court where you tell the judge, we're not going to offer a claim construction. Do what you want.
You say it a different way. That's not how you say it. You say this claim gets its plain and ordinary meaning, and you don't tell anyone what it is. You just say plain and ordinary meaning. That's how you do it.
I've had the reverse situation where it wasn't construed by the district court, but not until the PTAB patent owner response was it construed by the patent owner. It wasn't a term that was in dispute during the claim construction briefing process. That happens a lot. District courts will only let you construe 10 terms, right?
Right.
But then this term comes up in the patent owner response, and as the petitioner, you had kind of no notice that this term was ever in dispute. To Lori's point, it means what it says on its face. So as the petitioner, you do get the chance to reply to that and address.
And that makes all sense in the world. I get that, but I mean, at least, and maybe I was misunderstanding, but literally in the cases that we were talking about on the ethics side, there was nothing. Is that what's?
I should have missed. No, I think the petitioner's coming in and saying plain and ordinary meaning or doesn't need construction. It's not something that, and I don't see that many where they're taking, well, we say this and they're going to say this, so we're just telling you. I mean, these are more like, we're not providing a construction because we don't think it needs one, plain and ordinary meaning. And then, but the Federal Circuit's been pretty clear, if you now, patent owner come in, and I think the case is Axios, and you say, okay, well, here's our construction, and and then in the decision to institute, the board adopts patent owner's construction, then, and it makes sense, then petitioner gets to come back on reply and argue about that claim construction.
So I
I
think,
guess it makes sense in one way, but I still, I mean, and I understand that, to contradict what I said earlier today about these terms and words and standards and tests don't really matter. But if you're the one with the ball and chain, you know, when I first started my career, we were always with the ball and chain because we always represented plaintiffs, a variety of plaintiffs, a variety of different matters. If you're the one with the ball and the chain, that used to mean an awful lot. You know, and I sense today it doesn't mean the same thing as it did when I was a young attorney.
well,
Just
I
look,
don't,
I mean-
I was going to say, oh, go ahead. 'Cause,
As a petitioner, you're not going to be successful if you don't figure out what the patent means.
Right.
So getting back to what Lori's saying, there's 3 buckets generally. Plain and ordinary meaning, it means X or Y, or it means something. We're not sure exactly what it means, but the prior art has at least this part of that. So if you are not addressing one of those three things in your petition, you're just not going to be successful. And so if I think about it that way, what we typically say, plain and ordinary meaning, if there's a term that we're really worried about, we say it probably means this, but it could mean that, like she said, and then we find and deal with that in the petition. Otherwise, I'm just asking for trouble. So, I mean, I don't know if that answers your question, but in conjunction, I have to do that, and we haven't talked about this yet, with my district court litigation. My district court litigation team has to drive what we're doing, because we cannot, quote, win the war on claim construction and ultimately potentially lose the IPR, and then when I'm from an IPR from a petitioner's perspective, and then I'm in district court with a really bad construction that's going to hurt me on my infringement issues. So we have to be balancing all of those at the same time.
So, and not to sidetrack you guys anymore about this, but how often would you say that it's just a plain and ordinary meaning from the petitioner results in it being successful, versus if you really thoughtfully go through it and say, well, this has to mean this, and then this prior art has that. I mean, is there a difference in the institution rate success? Is there a difference in the overall success? What are the best practices? And as secondary and third questions, does part of this have to do with the page limit, how many pages you have, or word count rather, and does another part of it have to do with the budget that you're given?
Let me just kick this off. We were talking earlier about patent quality. And I'm just going to tie it to that. The more claims I construe usually is because the patent wasn't written very well, and I have to figure out what those claims mean and explain it to the judges so they at least understand what we think the claims mean. So I'm going to eat up a lot of space when I've got a patent quality issue. And so when the patents are, I'll just say, worded less well compared to other patents, I'm going to spend more time on claim construction. If the claims are worded a little bit better, I'm going to spend less time on claim construction. It's kind of like an inverse relationship. Is what I see in general.
Okay.
My non-statistical survey of my own cases, I have the strong sense that the PTAB doesn't want to construe anything it doesn't have to construe. And so I see petitioners, trying to play to that, and a lot of times, as a patentee, I'm going to play to that as well, because maybe we don't know what the answer is yet at the district court, or maybe we have gotten to the point where we've exchanged contentions, but we don't have a decision yet on Markman, and so I do get the sense that if you cannot construe it, or not get bogged into a construction, then that's kind of what you do in certain circumstances.
Okay.
So again, I feel like taking a look at the big picture, because as a petitioner, you talk about the ball and chain, but I feel like the weight on me as a petitioner is immense, right? Because you're asked to do all of this like within 2 or 3 months for like not a huge budget. Before the litigation has gotten underway. And you're dealing with, in a lot of cases, I'll say, patent owners, every single term is plain and ordinary meaning, and they will not say what the plain and ordinary meaning is until you get your position down on paper, and they're like, well, plain and ordinary meaning means this very narrow thing.
Well, right, but it's
it's
your burden, so why should they have to come first?
I'm not saying they have to come first.
Right, in the district court, for example, if they're
Right.
exchanging, they'll just say plain and ordinary meaning until it matters.
Right. And so we have this, again, weird dynamic, right? So that's why, you know, I think early on, you know, maybe even 10 years ago, we talked about, should we do claim construction and IPR proceedings like early on? So there's, like in district court, where you put the claims out, have a claim construction, and then the case moves forward from that claim construction, instead of kind of everybody trying to, you know, throw out all these claim constructions during trial, and at the final written decision, the board kind of says, all right, here's finally what it means, right? And so, you know, to me, this issue is tough on both patent owners and petitioners, and I you know, don't think we have the system really ironed out as best as we can at this point.
Which is interesting, because, you know, I have always thought that it's strange that in some district courts have claim construction at different times than other district courts. And I remember being in law school when, or I had just got out of law school right after when Markman was decided. And I thought, okay, so the first big meaningful decision after this is going to be to tell us, when does this actually have to happen? You know, and here we are all those years later, almost 30 years later, and we still don't know whether it should be at the beginning, at the end, at the middle, you know, before summary judgment, you know, before jury instructions, before, and that to me just strikes me as really odd. I mean, does it strike either any? I mean, you guys are in the heart of it, right? Does it strike you as odd as it does me?
I see both sides of it, but even as an attorney for mostly patent owners, I'd like an early claim construction just because it narrows the case down nicely. And therefore, you know, at working on a budget, we spend less money. Or if we're going to get a bad claim construction, I want to get that bad claim construction early. But I see the other side, because a lot of times I don't want to put down on paper what I think it means until I see what you got. But realistically, I you know, like I said, I think Markman is a bellwether point in any litigation. I advise my clients, and you guys probably do too, you know, they're always saying, well, when is the best time to settle? And I say, well, you know, in most cases at this point, depending on who you're going up against, you're going to need a Markman and an IPR decision. You can't really settle as a patent owner for something more than nuisance value without that.
And it's funny that you say it, you know, because years ago when I started doing this as a young lawyer, the best time to settle was before Markman, because once you had Markman, you knew what the outcome was going to be. And how that has changed is rather interesting to me.
I don't, and you know, I don't want to disclose any trade secrets here, but no, it's honestly, I don't think that you can get a defendant to meaningfully engage with you until you have something that says that my patent is worth more than the paper it's written on, which is back to what we've been talking about all day.
Yeah. Guys, do you have anything to add to?
No, I echo what Meredith was saying, that the Markman and the, you know, institution decisions certainly are definite inflection points to, you know, make a settlement decision. If you get a bad Markman as the patent owner and you can't read, you know, 3 out of the 5 patents in the complaint on the defendant's products, you know, that's really going to affect the settlement negotiations. By contrast, if you get something that's more open, you know, you go to trial and see how it looks, petitioner.
Mm-hmm.
I would just add, if you're in multi-defendant litigation and you're thinking about settlement, you know, you want the IPR decision, but then you're going to have joinder issues after. So I personally think the value of settlement is higher beforehand, given the current status of joinder. So you might want to take that into account.
The higher before?
Because if they're time barred and you settle, and then the case, then the PTAB never institutes, then the other parties can't join.
Mm-hmm. Okay. So, Meredith.
Yes.
Take it away with your.
All right.
Are you ready to go on your rant? Just to let me know, we got,
I've got
about 15 minutes
I've
left.
got one more point. I thought this would be a really easy one. Really, I did, because I thought the federal. I mean, not the strategy of it. I think is fascinating. The federal circuit's kind of resolved that you can come back, and I thought that would be kind of the point. But the strategy, I think, is much more involved. So related to that, there's been a number of federal circuit cases talking about, like, what type of evidence can you add in an IPR that wasn't in the petition? And, you know, the interesting thing is, if you didn't put it in the petition, should you be able to add it later? And the Federal Circuit has come down and said, oh yes, and under SAS, under SAS, the SAS says, yes, there will be evidence that can be added later. The Federal Circuit says you can't have a new prima facie case, but you can have new evidence. And I find that disturbing as a patent owner, because I feel like the petitioner should get their case in on their petition. So I know you guys would feel differently, and I know there's Federal Circuit law all over. So,
Well, I don't. You're saying it a little strong for my taste.
that's okay.
New evidence as it relates to the proceeding, like for instance, claim construction, or what would a person of ordinary skill in the art understand this term to mean? If patent owner says it means this, and I said it meant Y, I should be able to put in more evidence as to why my position is
Absolutely.
correct.
I
And
agree.
I think we're, so new theories? No new theories. I get, that is pretty clear at this point in time. Now, if you're using the same references and they're big references, are you presenting a new theory? Now that's where it can get a little hairy. And so maybe that's what you're talking about.
So I'll maybe go on my little soapbox as a petitioner here. So I think the issue is, as a petitioner, you have 14,000 words, and you have to address your substantive case. If you have non-patent literature, you have to show public availability. You have to show motivation to combine if you're using combination. You may have to address 325D. You may have to address general plastic. You may have to address FinTiv, right? And so, oftentimes you may only have less than 10,000 words for your substantive case. And, there could be a lot of claims you need to cover, and you can't be guaranteed that you're going to get multiple petitions. So I've had a situation where I filed my petition, and the patent owner spent 11,000 words attacking motivation to combine, right? That is an imbalance that...
There's a reason we did that.
Well, yeah, there's a reason that you did that, but I don't have 11,000 words to present motivation to combine. And if I did, I could have pre-butted every single thing you said, right? Right? But I had to be very judicious in kind of what you put in your petition. So I think the 14,000 words kind of handcuffs you along with everything else now you have to do in the petition. So I agree you shouldn't have new theories, but I think it's fair that if the patent owner challenges public availability, you should be able to put in additional evidence of public availability. Like for motivation to combine, you should be able to provide extrinsic evidence supporting your motivation to combine or contradicting something a patent owner's evidence says about motivation to combine. So I do think in the interest of fairness of the overall proceeding, there has to be some give and take during the trial to allow petitioners to further develop the theories they have in the petition.
What if the petitioner made a... Oh, sorry. Go
I was
ahead.
just going to echo, to stand on the petitioner soapbox a little bit, right? The point of the trial, the point of the reply is to further develop the record. So, kind of a hard limit on any new evidence, I think it would be restrictive in what the board can consider to come to the right decision. So, if the opposing expert is taking a ridiculous position, we want to be able to expose that if needed. Same with, as Lori was saying, public availability, right? If it's a book in the library and you need just one extra piece of evidence to show that it was there, that should be part of the record.
Yeah, these evidentiary disputes, I mean, we have 3 really smart judges at the PTAB who I believe are trying to get it right, or trying to do the best job that they can. And they're really good, in my opinion, at distinguishing new arguments from rebuttal evidence. And so if we're really serious about deciding whether a patent is valid or not, give it to them all and let them make the decision. I mean, that's where I stand on it.
I was going to further comment, but I'm so impressed with that answer that I have no further comment. So my rant, my rant deals with the Federal Circuit, and we all know the Federal Circuit was formed in 1982 to provide more certainty in patent jurisprudence. I think for a long time it really did that, and of late it hasn't. And there are probably a number of reasons why it hasn't. We can go on a number of them, but I just want to look at one. And one of them is, if you look at the caseload of the Federal Circuit, its patent caseload has more than doubled, or I think a better way to look at it is more than 50% of its caseload right now comes out of the PTAB, where there's, somebody tell me how many judges? How many?
260.
260 judges. Divide that by 3 because they sit on panels of 3, and you're looking at 80-something judge groups. And now the Federal Circuit has to decide or rule on all those cases. So what does the Federal Circuit do? What does it do? It says, okay, these are coming up out of an agency. It's an expert agency. It's really smart and good at what it does. And so what does it do all day? It decides obviousness. That's what it does all day long. So the Federal Circuit says, all right, well, that's just great, because here's the expert agency on obviousness. They're very smart people. They're not going to make mistakes. And guess what? Facts are reviewed for substantial evidence. So here we are, the Federal Circuit, with over half our cases coming up from the PTAB, and we're deciding each and every one of them on whether the individual case itself had substantial evidence. And I don't think that's a good use for the Federal Circuit. I think the Federal Circuit is there to resolve doctrines, to make the law clearer, not to deal with each individual whether there's substantial evidence. And you know what? I think they're wrong, because what we're all forgetting is that patent law obviousness is a legal question with underlying factual issues. And what I don't see is the court addressing the legal issue. And I think they think, well, certainly the PTAB wouldn't make that mistake because they're experts in obviousness. This is what they do. But what if the substantial evidence that the PTAB relied on, and it was substantial, it was like 100 pages of substantialness. What if that was the wrong substantial evidence? That's a legal error. And so what I see are these decisions that go and look at the evidence, and it looks great, but they don't really decide whether that was the right evidence. And maybe if you look at the obviousness question, that wasn't quite right, and that is a legal error. There's a really good case where Judge Newman dissented, and I think it's Roku something, and she dissented from a case where they reversed and found that the patent should survive. So she went the exact opposite way of what you think Judge Newman would do. In any event, she said exactly this, and it touched me, and I've been looking at this, and I really believe that we've got this panel, this appellate level panel, one level below the Supreme Court, and it should be doing more than looking at substantial evidence.
Do you think the solution is like the de novo review like the district court does out of prosecution at times?
What do you mean? I don't understand.
You know, for example, with prosecution, right? If you are unsatisfied with the PTAB, you can go to the district court and get de novo review. Is that?
I don't know that de novo review is the right answer. I think there's a problem with the amount of case law coming up, you know, the amount of appeals coming up, because I don't know if they have double the patent cases. I mean, they have another clerk than they did 20 years ago, so that helps. But there's 12 of them and 86 judge groups at the PTAB, and I think there's a problem with them just rubber stamping it, because I'm not sure they're looking at the legal issues, because they're they have so many of these cases coming up one right after the other, and they're all the same. Look at the substantial evidence. So that's my rant. I don't think de novo would help, because, I mean, obviousness is really de novo if you can find the legal problem. Maybe attorneys need to point out the legal problem more often, but I think we're doing it. I just don't know that the judges, a lot of them really understand that if there's a legal problem, that trumps the substantial evidence issue.
So actually that leads into another one of my soapboxes I frequently find myself on, related to rehearing requests at the PTAB. And I don't think they're meaningful. I think...
I agree.
Yeah, I think it's a terrible process, frankly. And perhaps if there was a more meaningful request for rehearing process at the PTAB that parties could partake of both at institution and final written decision, perhaps you would see less appeals to the Federal Circuit. But I think now a party that feels like they didn't get a good decision at the PTAB, you know, if you file a request for rehearing, it's like wasting your money, right? I think the success rate is less than like 5%. I mean, it's extremely low, and it's usually only typographical errors that you actually get a meaningful review. And then director review is just so narrow that you could actually even fit into that box. So maybe, getting to your issue is if there was a meaningful process at the board to get a rehearing that doesn't go back to the same panel that, or a mix-up of the panel, maybe that would cut down on the cases that parties feel they need to appeal just to get their position heard by someone.
I would be open to something like that. I think you've got a good point.
Mm. I think when I look at the PTAB, the whole process of invalidating patents seems to me to be a lot of just second guessing what the person who before you decided the issue. And it's one thing when it's the examiner didn't have all the information and I've come forward with new information, late discovered, that sort of thing. But I think that's the benefit of thoughtfully rethinking some of these standards, because when you go up to an appellate court, it's not supposed to be because you would have done something different if you were the decider. You're not the decider. I'm here to decide whether there's a legal error that I need to fix. But I see the PTAB a lot of times doing that with examiners. They just decide things differently. And I think there's a lot of actors that decide things differently, and they don't adhere to the standard. And I think that would be one big fix. The other thing that I also noticed too is, and I've talked to others, and they notice it, including judges. I won't name any names, but it only ever seems that the Federal Circuit reverses when the patent owner has won. And I know that there's PTAB judges that have noticed that, and I don't know that that can't be the right, because if there's substantial evidence and the petitioner always wins when there's substantial evidence, why isn't there equal amount of substantial evidence and an equal number of upholding victories by the patent owner? So there's a lot of things that seem bifurcated, and I can understand why patent owners seem to think that the PTAB is unfair, which is why I think that there's a lot of little things that could be done to the PTAB that wouldn't really, I'm sorry, Scott Scott and I, we go back and forth, but would changing this standard matter? Probably not. Well, then why don't we? Why don't we just make it across the board the same thing? Well, if this or if that. And we're at the hour here now, but what I would like to ask you, kind of in keeping with our theme here, PTAB and parallel proceedings, what would you like to see done to make a better, fairer PTAB? And not to say that with any one decision it's not fair. What I mean is like the perception of a better, fair, because I think the PTAB right now suffers from a perception problem more than probably anything else. What could be done to the PTAB to inject it with an imprimatur of neutrality and fairness, to get it above the fray?
So I think that one of the things that Jim said earlier, I echo, is coming from the petitioner side, and I know Jim is on the other side, a little bit more consistency across the panels. To Meredith's point, there are 86 3-judge panels, or however many permutations you can come up with it. And if there was some more enforced consistency across decisions, across the case law and the whatever standard the board is applying, I think that would do a lot to benefit both patent owners and petitioners.
I agree with you completely. How would you do? I mean, the way I would do it and I don't know that you can do this with the statute. I don't know that you couldn't, but I would like to see sort of like an intermediate level appeal within the office, so that if there was an error, if there was a mistake, you didn't have to wait for director review. You didn't have to ask the same panel for rehearing. You could go to somebody else.
That is what the director review process is supposed to be, right?
Yeah,
the director review panel.
There's too few.
Right, exactly.
Right? I mean, because with that number of cases, there has to be more mistakes. And it's not to say anybody's bad, anybody's evil. It's just there's so many cases, there has to be error here or there that people didn't appreciate, and brought to light of somebody who wasn't looking at the case this closely, they would see it.
Well, you were talking about the Prevail Act earlier in this institution judges being different than final written decision judges, I think is a huge step towards, now we have 6 people, different panels, finding the same thing, right? And so I think that would be, I'm all for that. And then if you want to do a rehearing, 3 others, they have the staff to do it. They have the workhorses to do it. And while we're talking about things that we'd like to see change, one thing that really bothers me is that you can't challenge indefiniteness or written description when you're a petitioner, because some of the patents that get asserted against my clients are frankly terrible sometimes on those 2 issues. And if you really want to have a fix for some of these 112 issues and keeping people from going to district court and asserting these patents and nobody knows what they mean, let it get fixed at the PTAB. Limited 112 issues. And I'm a big supporter of indefiniteness, written description. And if we're talking about other fixes, to Lori's point, she now has like 9,000 words to actually merits of the case. Do some rulemaking. Fintive, you get 2,000 words. 325 and 314, whatever you want to make the numbers. Those are separate. Same thing with secondary considerations for a patent owner. Patent owner gets hosed on the other side. What they want to put secondary considerations in, and they got 5,000 words. Now they got nothing for the merits of their case.
Right.
So
it's an all or nothing. It's you're putting your chips in the center.
Seriously, and so have a separate rule. Oh, if you're going to do secondary considerations, you get an extra 5,000 words. Just make it a rule so everybody knows what the rules are, and then we can just live by those rules and understand that page limits for the case is 14,000, secondary considerations 5,000, whatever you want to do for 325, 314, that number of thousand, everybody's on the same page and not trying to do wiggle room with all these different word things that have to go on with a petition.
Yeah, I like that. That's great. Meredith, what do you think?
I like all these ideas, and I think a lot of them have come up today, have been good, and para is exciting for these reasons. Sometimes I think, what's the minimum thing? What is one thing that we could do? And then I think, okay, well, you got to go upstream, right? Because you go as farther upstream you go, the more that affects what happens downstream. So maybe if we had some type of presumption, and maybe it's just a presumption of validity, but some type of presumption that the examiner did his job. The examiner did his job, the examiner should be given deference, and maybe that requires some sort of better review in the patent office, I don't know. But then by the time the case gets downstream to the PTAB can say, I rely on my own agency, because you don't know how many times I've had clients say, I don't believe this. I got all these patents from this agency, and now the same agency's turned around and invalidated 4 of them.
Yeah.
So let's help the PTAB and the patent office help itself.
So what I would say is, with respect to that, is just to talk out of both sides of my mouth here. And I mentioned this earlier. I've seen some stuff that I just can't imagine. I don't understand how it got patented.
We all have.
And shocking stuff. And it's not stuff that you guys would ever deal with in PTAB, because it can't be, these things can't be valuable. They just can't. They made somebody money, like the patent attorney money, writing it up, but that's all. These things are shockingly, because I've been looking at simple stuff that you can use to teach somebody how to do various things, right? So everybody's got to be able to understand it. And on that level at the patent office, it's terrible. But I would be in favor of some kind of, the decision maker, the panel. I would not have an institution. I just have one judge. I don't know. Do you need 3 to decide whether to institute? Whatever the case may be, I like separating them out from the merits versus institution. But why can't there be, and I keep going back to the way that you do it in district court with the bankruptcy judges, this review of did the judge really thoroughly consider all the issues? If yes, then the bankruptcy judge gets a lot of deference. Why not have something like that? Did the examiner issue one of these crap patents that we all know, that split a hair down the middle, didn't give any meaningful information in the rules for allowance? It was issued on a first action, the invention. That should be a wholly different area of deference, like maybe 0 to the examiner. And I'd like to see some kind of sliding scale. If the examiner does more work and considered more things and really put in a lot of time and effort, and maybe the examiner had been examining in this space for a period of years, then maybe that should get more deference by the panel on institution, or maybe if not on institution, on merits. But I don't know. That's my rant. Lori,
Yeah, so
I'll give you the final word here.
So again, I think the PTAB provides a really important process in the patent litigation world. I think the reality is, examiners only have a very finite time to handle each case. And so, the fact that some of these patents are getting out that are not great quality is kind of the nature of the process. So there needs to be an administrative review in place. The other thing to point out is that I can't name kind of one case in the last probably 18 months where the actual patent owner, when the patent issued, is the one suing my client, right? These patents are often not in the hands of the person who actually acquired the patent, and they're being twisted into reading on things that, clearly wasn't intended when they were going through prosecution. So I think the PTAB provides a very valuable service to balance the patent litigation landscape. I will say, from my perspective, greater transparency, I think, would do a lot for the PTAB. Just like so everybody has a more kind of confidence of what's going on behind the scenes. I know when, the patent owner files their patent owner preliminary response, there is a question mark, do I get to reply on X, Y, and Z? How long until I have to ask for this, until I'm not going to be allowed to? You don't know, and because then you find out someone else got a reply on this issue, and then you didn't ask for it because you didn't think you were going to. So I think just more transparency and communication, so both sides feel like we're playing from the same rule book.
Yeah. No, great. I really appreciate that conversation. I think it was great, and we got a lot of great ideas come out today. We're going to try and follow up and document these. If any of you here on the panelists or anybody in the audience has any ideas, send them to us, because we are going to try and put together something after the conference. It doesn't need to be a conference paper or anything, but just to put out the good ideas that we heard throughout this process. Meredith, did you have one final thought?
I have an idea, and I just thought of it, but another issue that we deal with in these parallel litigations is 101. And so how do you backdoor 101 into an IPR? Well, you do it because the patent owner maybe lost on 101 at the district court. Now they're in an IPR, and so they're trying to amend in the IPR to get around the 101 rejection. Mm-hmm. So that, I think, is another big topic that's a nice discussion topic that we could handle on a different day.
Yeah, excellent. Yes, because we're cutting into the cocktail party time. So hopefully you will all join us for a drink and some hors d'oeuvres, and we will see you tomorrow morning, those of you, all the rest of you.
Thank you.
Have a good night.
Thanks.
Thank you.
Thank you.